the Friday judgments of Supreme Court, which overturned verdicts of the Court of Appeal on governorship election cases in Plateau, Kano, and Zamfara states, have sparked a crisis of confidence in the appellate court. Delivering the judgments, the apex court has berated some justices of the appellate court over the quality of their judgments in the governorship election petition brought before them. More intriguing was the Plateau State governorship petition case, which has caused outrage among some senior lawyers who had lamented that the 11 national and state assembly members sacked by the appellate court decision have no judicial remedy. However, while the Supreme Court on Friday overturned the judgment of the appeal court on governorship election, affirmed the victory of Governor Mufwang, the sacked state and federal lawmakers cannot take their appeals to the Supreme Court based on the electoral laws, which terminate their appeals at the Court of Appeal. Joining us on the morning show to discuss the latest Supreme Court judgment, which has caused a lack of confidence in the appeal court ruling, is Abiodun Owonikoko, a senior advocate of Nigeria. Welcome to the show, sir. And I can hear you clearing your throat. Good to see you this year. The last time I saw you was last year. And I'll say Happy New Year to you because I'm seeing the brand new you in this brand new year. And God bless you. Good to see you, sir.
Good morning, Mr. Rufai. Happy New Year, Pro Max.
Pro Max.
Because we need to energize the greetings now. Pro Max.
Pro Max. Okay.
Because we are now going to third week.
Third week, okay, Pro Max.
Ayo, my sister Ayo.
Good morning.
Happy New Year.
And Happy New Year. Welcome to the show.
You kept us busy during the holidays.
Yes, absolutely.
We're enjoying you. Are still giving us, keeping us informed.
Yeah, essential services.
Thank you very much.
Thank you very much, sir.
All right, help us make sense of what one of the justices of the Supreme Court, Owonikoko, did say, that I know people will have suffered from this. I mean, should people suffer from the justice system that is supposed to get them justice?
Thank you. I happened to have been at the Supreme Court on Friday, so I sat through all the 8 judgments. Some of the reports in the media actually were passed as comments, remarks after judgments were delivered. For instance, they are well-articulated positions that resonate with those of us who are concerned about the public in our justice system. But I just wish to caution that when the hard copy of the judgments are released, if some of these comments don't feature there should be no insinuation that they have doctored their judgments. It's normal that for cases of those weighty disputes, the court's view can be expressed in different ways. Now, the first judgment was Lagos, which was read almost in full by Justice Garba. But because there are so many of them, after Lagos State judgment, most of the other ones were just delivered in summary. Each of the justices that delivered the lead judgment will highlight key points in the judgment. For instance, the Kano judgment, which was a condensed judgment in one appeal, intended to cover 9 appeals. There were 9 appeals from Kano, from the judgment of the Court of Appeal. But at the hearing, I happen to have been involved. The Court of Appeal, Supreme Court invited counsel to agree on which of them was the signature judgment that they thought, if taken, will address all the issues. And they agreed on the appeal by Governor Abba Yusuf. And the judgment in that particular appeal was the one that all other ones were to abide. So I just wish to make that observation that some of the things that were reported were correctly reported, but they are not necessarily part of the actual judgment delivered, because most of the judgment were paraphrased. So with that clarity, with that clarification coming, I think we can proceed. I believe that of the 8 cases there, Lagos turned on the issue of citizenship. Kano turned on the issue of invalidation of ballot. Zamfara turned on the issue of inconclusive election. Plateau turned on the issue of PDP not having a structure and the judgment of a high court having not been obeyed. Alex Oti's case turned on the issue of his alleged decampment, belated decampment, which they claim now denied him right to contest, that his name was not on the Labour Party's register because he was originally an APC aspirant. Cross River was about alleged non-qualification of the governor on account of his not having attended a secondary school. When the governor had been a senator, he's a graduate that's undisputed. So I think that essentially, then Bauchi turned on Section 73-2, which interestingly was a test case, and their lordships, while they found that the issue was well taken, that it was not shown that it affected the election in terms of audit trail of election materials. But the critical cases, which I believe the populace are interested in today, will be Plateau. And Plateau because there are a number of outstanding issues from Plateau. 26 or so legislators have had to have their victories undone through the court based on the same set of pleadings and facts that the Supreme Court reviewed and held were not available as basis for election petition, and so returned Governor Mutwang. It then meant that if those other people had a chance to have gone further to Supreme Court to challenge the judgment of the Court of Appeal along the same line, the rule of certainty suggests that they probably too will have emerged victorious at the Supreme Court. But unfortunately, on the first blush, it does not look as if they have any further recourse. But I think because of this discussion, I take a slightly different view.
All right, okay. Talking about recourse, the PDP, through its Deputy National Publicity Secretary, has said that they were going to seek a judicial review by approaching relevant judiciary and federal judiciary arms to review the judgments by the appeal court. That's their stance. I'd like to get your take on that. What do you think would be, or what do you assume would be the outcome of this judicial review? Whilst Mr. Mike Ozekome, also a lawyer, has said that in his view, he doesn't see this as being reversible. So we're going to have to suffer, or perhaps the consequence of this action would be for the next 4 years. What's your take on this?
My take is I hope they are being properly advised by their lawyers. Even if the person is a lawyer himself, in the matter in which is involved, there's a tendency to be a bit emotional. Judicial redress is clearly separate and distinct from administrative redress. Any approach to NJC is not an approach to Supreme Court or to any court for reprieve. It must be an attempt to invoke the administrative powers of NJC, usually which is disciplinary. The NJC does not review judgment, cannot review judgment, cannot reverse judgment. So it doesn't appear to me that that is a viable option to pursue, unless the whole idea is simply to just have the judges affected to be sanctioned. And that will not actually address the real issue of justice that the public and the affected litigants are looking at. So, and in that respect, I've not heard it being said that the justices that were involved in those cases were in any way guilty of malpractice or fraud. Because if that was the case, even if that was the case of Umana and Atta is to the effect by the Supreme Court that if a judgment is obtained by fraud, it does not entitle the Supreme Court to reopen or revisit it. You can only go after the judgment by way of an action to challenge it as a judgment obtained by fraud, by a fresh action. So that is out of it. If it's about the judges having gotten it wrong, which of course is the implication of the Supreme Court upholding the Plateau governor's case, that is also one of the prerogatives of judges, that they can be right, they can be wrong. They can be grossly right, they can be grossly perverse. That also does not impact on the judgment itself as a valid judgment until it is set aside. It, however, says a lot about the quality of the judgment and the judicial officers involved. We should, in any event, reflect on their career progression, especially as they are Court of Appeal justices. They still have one more ladder to climb. Judges who are involved in this kind of thing, especially where the Supreme Court had to come out heavily to sanction and excoriate them, should by now be reticent. They should be contrite, and that we cannot afford judges being open to any form of review. It means that those kind of judges need more study at the Court of Appeal before they are ever considered. for elevation to Supreme Court. It's not new. I've recalled a case of a judge of the Federal High Court against whom there was a petition, and the decision of NJC was that because of a demonstrable lack of competence and capacity to understand law, she should never be considered for elevation to the Court of Appeal. It's in the record. So that has happened. In this kind of thing, what I will expect for those who seek, other than judicial recourse, some form of other mitigation or reprieve to do, is to see how they can make a case why those judges who are involved in this may have to have their progression delayed so that they can learn better. They can get more seasoned before they are considered for more onerous responsibility in the hierarchy of our court. So that's what I can say for now. In terms of the options available, now I've said that I take a different view. It's like because if you look at our precedents, the first attempt to try this kind of thing, taking a legislative house election judgment at the Court of Appeal to Supreme Court, was in the case of Onugu in 1999, as we were transitioning to the democracy. The senatorial election, I think, is from one of the eastern states. And the Supreme Court were very clear that because the decree that established the appellate process for the transitional election gave Court of Appeal final authority to determine those matters, they had no judgment. Whether the Court of Appeal was right, was wrong, was perverse, it still does not open a window for you to come and review or test the correctness of their judgment at the Supreme Court. So they declined to hear that case. However, fast forward, in the case of Ucha and Onwe, the Supreme Court took a different view in respect of a legislative senatorial election from Ebonyi, where a senatorial candidate of a party was substituted unlawfully for somebody who contested for governorship, and that person was returned as winner of the election. The matter went to court, to the tribunal, and to the Court of Appeal. The Court of Appeal ruled that, took a decision, and the man went to Supreme Court. Supreme Court entertained that case and returned Senator Ali Ucha as senator because from the records, the person returned was shown to be governorship aspirant and candidate of the party. And he said he was not validly substituted. There was never a substitution. Supreme Court, looking at the case, then entertained the case and they returned Ali Ucha as senator. Even notwithstanding that the constitution was clear, 2463, that finality of court of the judgment election petition appeal other than governor and president cannot be reopened. So the Supreme Court find a basis to do that on account of the fact that if that issue had gone the right way, the Court of Appeal had no jurisdiction to have taken it. Now, the second point, the second case that I also like to reference is the Dangana and Usman. That also was a case where parties, PDP, I believe, and APC had issues about the procedure for nomination of candidate of one of the parties, claiming that INEC did not supervise or monitor the primaries. So they made it one of their complaints in their petition. I think the tribunal overruled the objection to the fact that, on the point that it was a pre-election matter. On appeal to Court of Appeal, the Court of Appeal reversed the tribunal. Interestingly, they then appealed to Supreme Court as if it was as of right. And Supreme Court held that court jurisdiction is never conferred by agreement. It's not conferred because it is in the interest of justice. It's also not denied simply because it's inconvenient. And that therefore, in that case, the Supreme Court entertained the case and decided the matter and returned the candidate of the party that was declared by INEC, saying that Court of Appeal did not have jurisdiction to hear the matter because by the very nature of the case from day one, it was having to do with election matter. So these two cases, if properly, analyzed, might create a window, a pathway for the Plateau victims of the decision in those cases to, in this case, invoke what I call the inquisition jurisdiction of the Supreme Court, which is jurisdiction for the court to determine whether or not it has jurisdiction. How do you do that? I think that applying to Supreme Court as a test case for leave to appeal that judgment on the basis that what the Court of Appeal, sitting as a tribunal appellate court, decided was not a matter for them, neither was it a matter within the context of the election tribunal that heard the matter. In which case, if it had gone the right way, it will have ended up at the Supreme Court. That being so, it's a matter that Supreme Court, on the authority of Onwe, that I said, Ucha, and on the authority of Dangana, Supreme Court may find a reason, especially given the indication from them that they found that judgment to be most unjust, whether it's in passing or not. It will be very easy to satisfy the court that there is an arguable and peculiar case in this instance, not because Supreme Court will be sitting on appeal over judgment of Court of Appeal, but because the Court of Appeal in the first place did not have jurisdiction at all to sit on that matter as an appellate court from a tribunal when it has to do with party structure of one party and their primaries and the judgment of a high court that went to Court of Appeal as a pre-election matter. So I think this window can be explored by way of applying to Supreme Court for leave to appeal on ground of jurisdiction. That the jurisdiction to determine that issue to finality vested in the Supreme Court if they had gone to the right court. And that having gone to the Supreme Court of Appeal in the wrong way, there's a window now for Supreme Court to assume jurisdiction whether or not it was right for that matter to have been taken up by the Court of Appeal. And if it so finds that it is not so, Supreme Court, in the case of Iyoto, has jurisdiction to now say, retrieve the certificate of return given to those people based on the judgment and give it back. It was so done in the case of Jeva and Iyoto. So there are a number of things involved there that I believe that lawyers have their work cut out.
Okay, Mr. Owonikoko, and I'm very happy that you cited that, the capacity to be able to invoke that inquisitory nature of the Supreme Court in this regard, you know, in the spirit of justice. And thank you so much for citing those two case laws. Very important. And I'm sure lawyers are scampering and working around that. Probably they should do that. But I'd like to ask you this. I believe the reason why we have many judges decide a particular case is to be able to have a variance as regards opinion. So even if one judge in his allusion gets it wrong, there should be sort of like a check and balance by the other judge in there. But that was not the case in most of these judgments because they were sweeping. Is it that we didn't have other Court of Appeal judges that could at least strike the balance? And we have powerful dissenting judgments as regards all of these cases that went this way. It's really the Plateau case. Secondly, we had seen copious camera evidence. No, hang on a minute, sir. Secondly, we had seen copious camera evidence where the president of the Court of Appeal, Dr. Mansa, went ahead to even defend, because, you know, a lot of eyebrows were raised as regards this judgment in the first place. And she went out to even defend this judgment, some of these judgments that have now been shown otherwise by the Supreme Court. So the Court of Appeal, like they say in local parlance, fully chested these judgments as their own judgments. But now to see things as elementary. What do you say to this?
Well, I'll have to say that I'm not aware that the President of Court of Appeal has weighed in on this judgment. If at all she did that, it will not be as a judicial pronouncement. Probably is a remark at an event, which should not be taken as a judgment of court, if that were to be. I recall that there was supposed to have been one of the panel members who went somewhere in Adamawa for a function and seemed to be justifying the reason for their judgment. But even that, I think it's a bit off mark for the judge, knowing that the matter was still fresh, to go and be making comments about it. But that having been said, what I think people are worried about in the respect of Plateau was that a single panel had all the appeals. And that did not allow for diversity of views. Because even when they sit as 3 or 5, they still have conferences where other members of the Court of Appeal feed in their views so that they can have common thoughts about how some of these similar issues can be decided. It's not clear to me if that opportunity presented itself in case of Plateau. We did so many of these cases, and in each of the states, you have different panel for governorship, different panel for senatorial, just so that they can spread the load of work, the workload. So I wouldn't know. That might have the idea that maybe there should be uniformity of decision might have been the underarching reason why the same panel. But it's now been shown that it was perhaps a wrong approach to go. The other point to make is that in this kind of matters anyway, Court of Appeal is the final court. And after the final court has given a decision, anybody can speak. That's why I'm able to speak today about all these judgments. So it's not even out of place for a judgment that has been determined to finalize for a judge to comment about it, for academics to comment about it, for the public also to critique it. So I guess that's the impetus for people making comment about knowing that it's supposed to have reached the final bus stop. But from what we are seeing now, and given the stand or indication of the articles of the Supreme Court, I think that there's a window that something can be done about it judicially without sacrificing constitutionalism. Beyond that, however, it's not every case that requires judicial solution. This is already a case of a miscarriage. There is a mishap. The entire polity normally should sit down when we are interested in the country to say, look, are there other ways we can address this issue? For instance, if this was something that happened in a country where people have integrity, all members of the National Assembly, House of Assembly, that benefited from that judgment, in view of what Supreme Court has said, should on their own offer to resign, and then they all go for by-election. This is what I would have expected to happen from people that have integrity. But you see, when we as lawyers cannot even agree on whether the right approach is it, then you can't blame them. But I'm just saying, in case some of them are thinking in that direction, it might be the honorable thing to do. So everybody will have a second chance. The injustice done would, one way or the other, have been in a way mitigated. That's one option. The other option also is that the judges who can be shown to have malevolently, traduced or breached the rights of the litigant in this case, even if they are on course to go to Supreme Court now, the President of Nigeria has power of veto over nominees, even although they have been cleared. You remember that for over a year, judges who are cleared to go to Supreme Court, President Buhari did not do the swearing in until after some time. So if there is any of them that there's a very serious concern about his fitness to go to Supreme Court in the interest of the entire country, the president can, without necessarily rejecting, he can withhold his invitation for swearing in.
All right.
And be honest there, because this country belongs to all of us.
Yeah, absolutely. And rightly said,
Yes.
which leads me to the question I was going to ask you, because you have stated what's the case in the area of Justice Moore Adumain. Justice Moore Adumain wrote the lead judgment for the Kano State appeal, for the Kano State governorship election petition, which was overturned at the Supreme Court. So one of the judgments, perhaps, shall we say, criticized or faulted by the judgment on Friday. However, he's been cleared by the Senate to become one of the, I believe, 10 justices who will be elevated to being Supreme Court judges, even though he hasn't been sworn in yet by the president. And this speaks to a wider conversation around even the appointment of judges, and then brings in again the conversation around perhaps some senior lawyers being, absorbed or perhaps being accepted into being judges at the Supreme Court. So what would you say the same applies to Justice Moore Adumain, who from the South, who wrote the lead judgment in the appeal court situation in the Kano State governorship petition?
Disclaimer here. I happen to be one of the lead counsel to Governor Abba Yusuf in that matter. And I don't think it is fair for me to personalize the issue in respect of the learned justice you have mentioned. It was not a judgment by one judge. There are 3 judges that heard the matter. So if something went wrong, that does not necessarily mean that they did something fraudulently. It might just be their own view of how the matter should be decided. After all, at the tribunal as well, the tribunal was the originator of the whole crisis that went to his chambers and made it clear in judgment that they discovered 165,000 ballot papers that were not stamped and used that one to do a new arithmetic and return somebody else. Somebody else that was not even a party in the petition. The person who had even congratulated Governor Abba Yusuf that he was not interested. So I don't think it is fair for me. But if for any reason, those who have information that they think are weighty enough to prevent anybody from going to Supreme Court, this is the time for them to act. And it is not to NJC anymore. It is not to National Assembly because they have been cleared. It is to the president. If people actually want to put their mouth where they are, whatever, I don't know where they, I forgot
the
where
money
they
where
put
their
it.
mouth is.
Then they have to go after it. You remember, before the election, thank you very much. You remember, before election, Rufai, you remember I made the point that this election was more important because of the power that the president would wield to appoint at least 10 judges of the Supreme Court on assumption of office. You remember I said it. Yeah. I was shocked that Labour Party and all whatnot that were in the National Assembly, they did not take these justices through any rigorous screening. As opposition party, they were cleared in less than 24 hours, which is scandalous. I remember that before Trump left office, he pocketed many appointees to the bench against whom he did not feel comfortable, because that's part of the prerogative of the president. I do not see why, when for the first time in our history, we are having a president who has a chance to appoint 10 judges at the same time, who will rush the process and not get the best value for the exercise. I think what has happened is an eye-opener for us to revisit how we take the issue of screening justice at the happiness level, where they have the power of life and death over all of us. We should take it more seriously. And an opportunity to probably, tinker with that process. And just like the president has been reacting to other concerns of Nigerians, is it corruption in the material ministry, the issue of palliative, subsidy and everything, he's been responding. I think there is sufficient noise made and good case made. The president may respond one way or the other to this. I'll give you one simple example of how things like this are done when statesmanship prevail. There was justice of the Court of Appeal that was going to the Supreme Court. At the point of his being recommended, there was a petition that was written properly. That petition prevented his elevation that year, and somebody else from his own zone was elevated. To Court of Appeal. By the time the opening came in Supreme Court from that same, they corrected that error by ensuring that he went to Supreme Court before the other person. The petition was totally biased. And it was his case that was used to now say that if anybody is due for recommendation, objection and all whatnot against him must come early enough for him to be able to respond. So our system is sufficiently robust to address some of these things so that we don't unduly complicate matters. I'm just giving that as an example. Absolutely. The final point I wish to make is that in support of the view I expressed now, there is actually a case that we used to test this matter in the course of this process. You remember that Dr. Alex Oti had a judgment delivered a week to his swearing in Kano. That case lasted 8 days. It was not joined, and the court ruled that it should not be sworn in. We had to apply for leave to appeal as an interested party against that judgment. We applied, we got leave, and their appeal was taken after leave was given in June. The judgment was delivered in October. The other side alleged that because it was not delivered within 60 days, then that judgment was a nullity. Based on that, they went to Supreme Court. Supreme Court not only dismissed their case, it awarded 5 million naira cost in favor of each of the respondents against the lawyer that filed that process. Because they said that when you file a pre-election matter after election has been held and petition are pending, that cannot be a pre-election matter that will now constrict the court to determine within days. So I think that part of what should play out in this matter, if the litigants are convinced of their option, is that the time limit of 60 days may actually not apply in their case. If in the first place, that case ought not to have gone to either the tribunal or the Court of Appeal.
Brilliant. Thank you so much. It's been such an insightful conversation with you this morning, Mr. Abiodun Owonikoko, SAN, just dissecting the matter on ground and also very important salient points you've made this morning. I do believe some lawyers owe you consultation fee after the interview this morning. Thank you very much.